So, hi, good day everyone. Good evening, sir and classmates. I'm Dexter Caide, and I'm going to report about the Article 1245 up to Article 1251. So, let's get started. Article 1245. Dation in payment whereby property is alienated to the creditor in satisfaction of a debt in money shall be governed by the law of sales. So, what is meaning of dation in payment? Dation in payment, adjudication or dation and pago is the conveyance of ownership of a thing by the debtor to creditor as an accepted equivalent of performance of monetary obligation. It is a special form of payment because it is not the ordinary way of extinguishing an obligation. A debt in money is satisfied not by the payment of money but by the transmission of ownership of a thing by the debtor to the creditor. So, sabi dito, ang dation in payment daw ay special form of payment. It is a mode of extinguishment of an obligation whereby yung ibibigay ni debtor kay creditor ay property in order to satisfy nga yung monetary debt. So, in this situation, yung utang ni debtor is monetary pero yung ibabayad niya kay creditor is yung property niya. So, ano nga ba yung mga requisites in dation of payment? In order that there be a valid dation in payment, the following are the requisites. Number 1, there must be performance of the prestation in lieu of payment animo solvendi, which may consist in the delivery of a corporeal thing or a real thing or a credit against a third person. Number 2, there must be some difference between the prestation due and that is which is given in substitution, aliud pro, alio. And 3, there must be an agreement between the creditor and the debtor that the obligation is immediately extinguished by the reason of performance of a prestation different from that due. So, governing law. The law of sales govern because dation in payment may be considered a species of sales in which amount of the debt becomes the price of the thing alienated. As such, the essential elements of a contract must be present. So, sabi dito, sabi nga sa Article 1245, it shall be governed by the law of sales. Kasi nga, it partakes in a sense na yung nature of sales. It is like if the creditor is buying the property of the debtor at ang bayad ay ang utang niya. Also, the conveyance must be deemed to extinguish the obligation to the extent only of the value of the property. So, as agreed or as may be proved. Unless yung both parties have considered the property na full payment na. So, here is an example. D owes C 15,000 pesos. Fulfill the obligation, D, with the consent of C, delivers a piano. If the piano, however, is worth less than 15,000, the conveyance must be deemed to extinguish the obligation to the extent only of the value of the piano as agreed or as may be proved, unless the parties have considered the piano by their agreement, expressed or implied, as full payment, in which case the obligation of D is totally extinguished. So, sa example na to, si D nga may utang na 15,000 kay C. So, ang ginawa niya, imbis na 15,000 na money yung ibayad niya kay C, yung piano na lang niya. Pero, it is worth less than 15,000 nga. Pero, pwede nila, ang mangyayari doon, pwede naman, kung nasa agreement nila na full payment na yung piano, na pambayad doon sa debt sa monetary debt, then pwede naman. If not, kung wala sa agreement nila, kung ayaw ni C na full payment yon, pagpalagay na natin na presyo ng piano is 10,000 pesos. So, ang utang na monetary debt is 15,000 pesos. So, may utang pa si D kay C na 5,000 pesos. Yun pa. So, i-distinguish natin yung sale from dacion in payment. So, ito yung pagkakaiba nila ng sale at dacion in payment. Sa sale, no pre-existing credit. Sa dacion in payment, there is pre-existing credit. Kung sa sale, obligations are created, dun pa lang nagsisimula yung obligation. Sa dacion in payment naman, obligations are extinguished. So yun nga, sa dacion in payment, obligations are extinguished. Sa next, sa sale, the cost is the price paid from the viewpoint of the seller or the acquisition of things sold from the viewpoint of the buyer. Sa dacion in payment, the extinguishment of the debt from the viewpoint of the debtor or the acquisition of the object in lieu of the credit from the viewpoint of the creditor. Next, sa sale, the buyer has still to pay the price. Babayaran niya pa lang yung product. So, sa dacion in payment, the payment is received before the contract is perfected, which is to be charged against the debtor's debt. Sa sale, the parties deliver and receive the thing as seller and buyer. The dacion in payment as debtor and creditor. And last, sa sale, the giving of the price may generally end the obligation. Sa dacion in payment, the giving of object in lieu of the credit may extinguish completely or only partially the credit, depending sa magiging agreement ni debtor at creditor. Now, let's move on to Article 1246. When the obligation consists in the delivery of an indeterminate thing or generic thing whose quality and circumstances have not been stated, the creditor cannot demand a thing of a superior quality. Neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. So, next, rule of the medium quality. If the obligation consists in the delivery of a specific thing, the very thing due must be delivered. However, if the obligation is to deliver a generic thing, the purpose of the obligation and the other circumstances shall be taken into consideration to determine the quality or kind of thing to be delivered. Article 1246 is a principle of equity in that it supplies justice in cases where there is lack of precise declaration in obligation of the quality or kind of thing to be delivered. It is always hard to find one thing that is exactly similar to another. If there is disagreement between the parties, the law steps in and determines whether the contract has been complied or not according to the circumstances. The benefit of this article may be waived by the creditor by accepting a thing of inferior quality and by the debtor by deliberating of superior quality. So, sa rule na to, tinutukoy dito is yung indeterminate or generic thing, which is hindi pa talaga alam. Ito yung mga bagay na hindi similar o hindi tukoy, hindi talaga alam. So, it is stated dito na si creditor ay di pwedeng mag-demand kay debtor ng superior quality Pero kung gusto niya, pwede siyang mag-accept ng inferior quality if okay lang sa kanya. Sa kabilang banda, si debtor naman di siya pwedeng mag-deliver ng inferior quality, pero if okay lang sa kanya, pwede siya mag-deliver ng superior quality. So, example tayo. S promised to deliver to B a horse. B cannot compel S to deliver a prize-winning racehorse. Neither can S require B to accept an old sickly horse. Okay, there are another pa. If B owns a stable of racehorses and horse racing is his main diversion in life, which is pago known to S, and the price agreed upon is reasonable of the price of racehorse, then S must deliver a racehorse. Next, if B happens to be Kalesa driver and B agreed to pay S for the horse an amount which is reasonable price of a horse for Kalesa, then that kind of horse may be delivered. Last, if B is a veterinary doctor and his purpose in buying a horse is to examine its organs in connection with his work, this or other relevant circumstances may show that the old sickly horse was intended by the parties to be delivered. Next, Article 1247. Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial cost, the rules of court shall govern. So, sinasabi sa prestation na to na Article 1247 na si debtor ang may obligation to pay for extrajudicial expenses unless may stipulation na si creditor daw ang magbabayad ng mga extrajudicial expenses for the payment. If walang agreement kung sinong magbabayad ng extrajudicial expenses required by the payment, then si debtor ang magbabayad. So bakit si debtor talagang magbabayad? Kasi it is provided under Article 1247 and ayun yung sinasabi ng batas. And the reason for this then is si debtor din naman ang magbe-benefit dahil pag na-execute or na-perform na yung payment, kung na complete na yung payment, yung obligation ni debtor ang ma-extinguish. Next, Article 1248. Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. So sabi dito, the payment must be complete. Di pwedeng partial. So kailan ba pwedeng maging partial ang payment? Ano yung mga exceptions? Ayan yung pag-uusapan natin. Ayan. When partial performance obligation allowed. Number 1, when there is an express stipulation to that effect. So, if nasa agreement nila na partial ang payment, pwede ito maging partial payment. Next, when the debt is in part liquidated, definitely determined or determinable, and in part unliquidated. Next, when the different prestations in which the obligation consists are subject to different terms or conditions which affect some of them. When the parties know that the obligation reasonably cannot be expected to be performed completely at one time. And last, when there is abuse or right of if good faith requires acceptance. So, Here are the examples. Number 1. D is indebted to C for 5,000 pesos due today. D cannot compel C to receive 4,000 in partial payment of the obligation. Neither can C require D to pay only 4,000 pesos unless there is an agreement to the contrary. So dito, si D may utang kay C na 5,000 pesos. Hindi pwedeng 4,000 lang yung ibayad ni D kay C. And si C, hindi din naman niya pwedeng sabihin kay D na 4,000 muna yung ibayad. Number 2, if D owes C 5,000 pesos plus the share of C from the profit of a business which however has not yet been liquidated or determined, C may demand and D may effect the payment of 5,000 pesos which is already known. Ayan nga. Kung yung 5,000 pesos, ayun na yung yung kumbaga, kailangan buo na siyang ibigay ni D kay C. So, yung mga hindi pa alam na value na damage or anything, ayun nga, yung share of C sa profit ng business, pwedeng hindi muna kasi unliquidated pa siya. Number 3, if 4,000 pesos of the debt of D is due today and 1,000 tomorrow, the obligation can be complied with partially. Similarly, partial performance may be affected in the case of payment of the 1,000 pesos is subject to the fulfillment of a condition. Last, number 4, S obliged himself to deliver 50,000 bags of cement to B at the construction site of building. S make a first delivery of 5,000 bags, informing B that continuous deliveries will follow. In this case, B cannot, in good faith, refuse to accept the partial deliveries as long as they are sufficient for his construction needs. Then, in the currency which is legal tender in the Philippines, the delivery of promissory notes, payable to order, or bills of exchange, or other mercantile documents shall produce the effect of payment only when they have been cashed or when through the fault of the creditor they have been impaired. In the meantime, the action derived from the original obligation shall be held in the abeyance. So, what is like legal tender? Legal tender is that currency which a debtor can legally compel a creditor to accept in payment of a debt in money when tendered by the debtor in the right amount. So, legal tender, it is the currency which a debtor can legally compels na sa creditor na i-accept yung payment of a debt money when the debtor in the right amount. Currency siya na si debtor pwede niyang i-compel si creditor to accept kapag nagbayad siya. So, legal tender in the Philippines. In the Philippines, all coins and notes issued by the Bangko Sentral ng Pilipinas constitute legal tender of all debts, both public and or private, unless otherwise fixed by its monetary board. Coins are legal tender for amounts not exceeding 50 pesos for denominations of 0.25 centavos and above, and in amounts of exceeding 20 pesos for denominations of 10 centavos or less. All coins and bills above 1 pesos are therefore valid legal tenders for any amount. So sabi dito, yung kung 50 ipagpalagay natin na 50 pesos yung utang ni debtor kay creditor. So, ang pwede niya lang i-compel or ibayad kay creditor na pwedeng i-accept lang ni creditor is 25 centavo and above. Kung more than 50 pesos na yung ibabayad niya, hindi na pwede yung 0.25 centavo na ibayad niya kay creditor. So, if okay lang naman kay creditor na 0.25 centavos yung ibayad ni debtor, then okay lang din naman yon. So, next, yung 20 pesos naman daw is pwede magbayad or i-compel ni debtor kay creditor na 0.10 centavos or less. Pero kung more than 20 pesos, hindi na pwede niyang i-compel yon kay creditor. And yun nga ulit, kung okay lang naman din kay creditor na mag-accept ng 0.10 centavos, then pwede din naman. Now, payments by means of instruments of credits. Number 1, right of creditor to refuse or accept. So, under dito, promissory notes, checks, bills of exchange, and other commercial documents is not legal tender, and therefore the creditor cannot be compelled to accept them. This is true even though the check is certified or is manager's check. Next, number 2, payment for purpose of redemption. A redemption of property sold under execution, not rendered invalid by reason of the fact that the payment to the sheriff for the purpose of redemption by means of a check for the amount due. Last, number 3, effect on obligation. Under dito, payments by means of mercantile documents does not extinguish the obligation until they have been cashed or unless they have been impaired through the fault of the creditor. Article 1250. In case an extraordinary inflation or depletion of the currency stipulated should supervene, the value of the currency at the time of the establishment of the obligation shall be the basis of payment, unless there is an agreement to the contrary. Now let's define the meaning of inflation and depletion. Inflation is a sharp sudden increase of money or credit or both without a corresponding increase in business transactions. Inflation causes a drop in the value of money, resulting in the rise of general price level. So, inflation meaning nag-increase yung money nang wala siyang corresponding increase sa business transaction. Wala silang makitang dahilan kung bakit nag-increase yung money or credit. And nagre-result yon sa pagtaas ng general price level. So, now, depletion. Depletion is the reduction in volume and circulation of the available money or credit, resulting in a decline of the general price level. It is the opposite of inflation. So, yun. Basta dito, yung inflation and depletion, opposite sila to each other. So, let's read meron tayong tatlong requisites for application of Article 1250. Okay, number 1, there is an official declaration of extraordinary inflation or depletion from the Bangko Sentral ng Pilipinas. Number 2, the obligation is contractual in nature. So, ayun nga, because there is an stipulation, so it talks about contracts. Number 3, the parties expressly agreed to consider the effects of the extraordinary inflation or depletion. Now let's talk about the basis of payment in case of extraordinary inflation or depletion. Under Article 1250, the purchasing value of the currency at the time of the establishment of the obligation shall be the basis of payment. In case of extraordinary increase or decrease in the purchasing power of the currency, which the parties have could not have reasonably foreseen. This is, however, subject to the agreement of the parties to the contrary. The burden proving that there had been extraordinary inflation or depletion of the currency is upon the party that alleges it. So yun nga, Article 250 is only applicable to cases where contract or agreement is involved. So most importantly, the parties must agree to recognize the effect of extraordinary inflation or depletion. So at present, the inflation in the Philippines is only ordinary and not extraordinary. So if it becomes extraordinary, the basis of payment is the value of the currency at the time the obligation is constituted. So here is an example of it. D borrowed C 5,000 pesos payable after 5 years. On the maturity of the obligation, the value of 5,000 pesos dropped to 2,500 pesos because of inflation, or increased to 10,000 pesos because of depletion. In this case, assuming there is extraordinary inflation or depletion, the basis of payment shall be equivalent to the currency today to that 5 years ago. Hence, D is liable to pay 10,000 pesos or 2,500 pesos unless there is an agreement to the contrary. Example that D shall pay 5,000 pesos regardless of extraordinary decrease or increase in the purchasing power of the peso. So, may pagkakataon na dito sa Pilipinas magkakaroon ng inflation and depletion. Pwedeng tumaas or bumaba yung halaga ng pera. So, yun naman, may agreement naman sila na babayaran pa rin yung 5,000 pa rin yung babayaran despite na meron niyang inflation or depletion, ayun pa rin yung babayaran niya. So, devaluation and depreciation distinguish. Devaluation involves an official reduction in the value of one currency from an officially fixed level imposed by monetary authorities. Depreciation, on the other hand, refers to the downward change in the value of one currency in terms of the currency of other nations, which occurs as a result of market forces in the foreign exchange market. Ayun po. So the last article that I will tackle, of course, the Article 1251. Payment shall be made in the place designated in the obligation, there being no express stipulation, and if the undertaking is to deliver a determinate thing, the payment shall be made wherever the thing might be at the moment the obligation was constituted. In any other case, the place of payment shall be the domicile of the debtor. If the debtor changes his domicile in bad faith or after he has incurred in delay, the additional expenses shall be borne by him or bear by him. These provisions are without prejudice the venue under the rules of court. So, yun nga, Article 1251, this provision talks about the place where obligation shall be paid. So, let's get started. place where obligation shall be paid. Article 1251 gives rules regarding the place of the payment of an obligation without the prejudice to venue under the rules of court. Number 1. If there is a stipulation, the payment shall be made in the place designated. Number 2. If there is no stipulation and the thing to be delivered is specific, the payment shall be made at the place where the thing was, at the perfection of the contract. Last, if there's no stipulation and the thing to be delivered is generic, the place of payment shall be domicile of the debtors. In this case, the creditor bears the expenses in going to the debtor's place to accept payment. Last, the concept of domicile. Domicile is the place of a person's habitual residence. Residence is the only element of domicile. Residence simply requires bodily presence as an inhabitant in a given place, while domicile or legal residence requires bodily presence in that place and also an intention to make it one's domicile. Some cases make distinction between the two terms, but as generally used in statutes fixing venues, they are synonymous and convey the same meaning as the term inhabitant. The term residence is equated with domicile or legal residence as far as election law is concerned. That's all. Thank you.